Guys, we're so happy you're here, especially with all the crazy weather we've had. We're even more grateful than ever. We appreciate you being here at the Space and Rocket Center, and we're looking forward to some really great information and wonderful presenters who are going to share it. Today, you guys are ready for a treat. You are going to get to hear from Ryan Letson. He works at Holland & Knight as an attorney, and he specializes in representing technology clients across artificial intelligence, government contracting, and manufacturing sectors. He handles patent and trademark prosecution, counsels clients on AI and machine learning IP strategies, and manages technology transactions, including licensing agreements. Ryan's expertise spans emerging technologies from autonomous vehicles to biometric sensors and data communication networks. So it sounds like he does everything. I'm really excited, Ryan, to hear and learn about it. So you guys, please help me welcome Ryan to the stage.
Well, good morning. There are quite a fewer people here now than there were in the last session, so a little bit more intimate crowd, and definitely looking forward to speaking with y'all for a little while. As she mentioned, my name is Ryan Letson, and I am a partner at the firm of Holland & Knight. And today I'd like to talk to you a little bit about intellectual property and AI. So I don't know how many people in this room have ever encountered these types of questions before, but have you ever wondered, in the context of a patent, hey, I use ChatGPT to design a new circuit board. Well, can I patent that? Who invented that? Was it you? Was it ChatGPT? Was it the people who trained ChatGPT? Was it somebody who provided the data set that that the model used to create? Who is the one who is going to be the inventor? Well, in the context of copyright, if you use an AI tool to generate a melody, like a song, and then you have it arrange it into a full composition, is that something you can seek copyright registration for? Do you own copyright in that new melody that you've created with the AI tool? Or what if you're a defense contractor? What if you are somebody who works with the government and you have government customers, and the government says, hey, we would love to see and we need to see, as a matter of national security, the source code and the data associated with your AI system, and you're wondering, well, what do I have to tell them? Those are questions that are not necessarily hypotheticals or not abstract. These are things that people in this community and across the country are confronting each day. So my name's Ryan Letson. I am a intellectual property attorney, and so I handle patents, trademarks, copyrights, trade secrets, and agreements and transactions related to those things. But I also get the chance to work with clients who are companies in technology areas and who work with technology. And particularly, more and more these days, I get to work with folks who are employing or considering employing AI in their processes. So that's very relevant for this conference where we're talking about agentic AI and what impacts that might have on ownership of intellectual property rights that you have or that you may want to have. And so patent strategy, IP law, regulatory compliance. That's a little bit about me. I'm from Huntsville. I was born here and went to the University of Alabama, Roll Tide, to go to engineering school. Came back and worked for a large defense contractor for a period of time. That's where I met my wife. She did not go to Alabama. And so really have enjoyed being in Huntsville for my career, and have just enjoyed seeing it grow. So that's a little bit about me, but I'd like to, before we get into the patent and copyright system and how AI has impacted that and can impact rights in the patent and copyright system, I'd like to know a little bit more about you. And so in this audience, if you have been involved with the patent process as an inventor before, can you raise your hand? Super. What about folks who have been involved in representing someone who is an inventor seeking a patent, maybe as a patent agent or patent attorney? Okay, we have someone. So what about in the context of copyright? Have you ever sought copyright registration for something you've done before? Okay. And how many folks have done that on their own instead of working maybe with an attorney? Okay, very cool. So these are things that we see frequently and questions that we have, but it looks like there is some familiarity in this audience about the concepts at a high level, what a patent is and what copyrights are and what they protect. And so I expect that this will be useful. So just a quick overview of the patent system in the United States. It's been focused on human innovation essentially since its beginning. And obviously, in 1790, there was there were not AI tools that were available to folks who were inventing. Humans were the inventors, and that really wasn't something that was particularly contentious at the time, and it was something that was fairly clear. The Patent Office wasn't established until after 1790, but from the period after that, human innovation continued to be at the focus of what the Patent Office was doing and what the patent system in the United States was, focused on human creation. Go to the 2010s, you have the American Invents Act that passed. There's rules that come about with human invention. What's not mentioned here is an important decision that happened in 2014, the Alice decision, where you have a big impression about what is patentable subject matter and what are abstract ideas, and that whole system of case law and the precedent that's come down after that really influenced a lot of what it means to have a patentable invention. But humans are still really at the forefront of that, and we haven't gotten into enough or quite as much of the stuff that happened in 2023 when you really started to see more widespread use of generative AI take place. Pretty much from the outset, machines were able to create ideas that might have been novel, and that's different from software that's stored in memory that's just executing instructions, which the Patent Office and courts had confronted for quite some time. Just like I mentioned a second ago, that Alice decision from 2014, you had courts saying, hey, you can't just take things that people do in their head and put them in software and get a patent on it. That's not going to pass our subject matter eligibility test under Section 101 for patentability. So you can't just do that. Well, now, 2022, 2023, 2024, we start to see AI emerging as something that's in the mix now, and it's not just humans who are in the ideation and invention process. So 2024, 2025, you've got the USPTO and others who are trying to grapple with what is the law and what should we do when AI is involved in the invention process. So what does it mean when a machine generates an idea? Flash forward to today, and I think the overall takeaway is, well, using AI as a tool to create is a framework that seems like it's going to be emerging. It seems like what the USPTO is leaning toward, and what their recent guidance that we'll discuss in a few minutes seems to indicate. So, a lot of folks in this audience know what a patent is because you've been involved with the patent process before. But I find that there's still a little bit of a misconception about what a patent is and what a patent is not. So I want to talk about that real quick. So what a patent is an exclusive right to exclude others from practicing the patented invention for some period of time. And this was seen, a long time ago as a tool that was meant to incentivize innovation. You will get these exclusive rights for the term of your patent if you just disclose to the public what your invention is. And you do it in sufficient detail that people know where the boundaries of your invention are so that they can do their own innovations and commercialize them. So these are property rights that can be licensed, they can be sold, they can be used as collateral. A patent is not a right to practice the invention. Think about like a new training wheel that you have for a bicycle. You may own the patent on the training wheel, but do you own the bicycle's patent? Do you have the right to use that training wheel on a bicycle? Maybe, maybe not. Someone else may have a superior right to use a bicycle or to keep you from using the bicycle without getting permission or paying a fee. So patent is not the right to practice the invention. It's also not a shield from liability. It's not something that protects you from accusations that you have infringed somebody else's patent rights, or that you don't need a license to practice your invention. It's not a shield from infringement liability. And it also doesn't mean that you're going to have a commercially viable invention. There are a lot of patentable inventions that simply don't make commercial sense and that you probably wouldn't be wise to pursue in the marketplace. So again, disclosing your invention to the public in exchange for this 20-year from the earliest non-provisional filing date patent term is where we are today, and that's where things have stood for quite some time. So most of you may be familiar with that. What's patentable? We've got processes. Those are steps. Those are methods that allow you to achieve a result. They are also things that can be done not just in the human mind, but that can be carried out, practically. Then you have machines, which are devices with interrelated parts. That's something like a fastener or perhaps a new medical device. Then you have articles of manufacture. You have tangible, useful articles that can be produced. That is not some composition of matter, which we'll talk about in a second, or a machine, which we just described. Maybe a container with some new properties or something like that is a manufacture, article of manufacture. Then you have compositions of matter, and these are new substances, new chemicals, new compounds, like drug formulas, that sort of thing. Compositions of matter are another category. So, what else do you need to have in addition to falling within one of these areas of patentable subject matter? You need to have novelty under Section 102, so it has to be new, and it has to be non-obvious. So that's something that is where a lot of people who do patent prosecution will run into, that's one of the more prevalent considerations when someone believes something is truly novel is, well, if you take the prior art and you combine them, is that something that the teachings of the prior art, if they were to be combined, would it be obvious to somebody of ordinary skill to do that and get your patent, your invention that you want to patent? That obvious combination of known elements is something that can prevent you under Section 103 from getting a patent. So those are things that we grapple with when we're advising on what's patentable and what is not. Okay. What's not patentable also includes purely abstract ideas. That's just ideas, theories, that kind of thing. Thought processes, mental steps that are only done in the human mind. Those things are abstract ideas. Just moving data around, by the way, and if you're doing that in software, the Alice case that I mentioned a moment ago is cited there. There's cases that have interpreted the law after that and Section 101 to preclude just moving data around or simply taking it and rearranging it as something that's novel and that meets that patentability standard under 101. So just noting that. Laws of nature. What happens in a natural state is not something that's going to meet your patent eligible subject matter standard. Naturally occurring gene sequences are something that haven't been modified, that sort of thing. Those are examples of non-patentable subject matter. Natural phenomena, so observable natural things that happen as they occur, like a natural biological process, that's not going to work. And just human mental steps and observations, not patentable as well. So some of this stuff is common sense. But, okay, so what happens when AI gets thrown into the mix? Traditionally, you have a human who's going to form the idea, and they're going to work on it, they're going to experiment, they're going to research, and they're going to try to reduce it to practice. And I'll talk about that again just in a moment. But they'll disclose the invention through a patent application, and they'll want exclusive rights to that, and the patent system will grant that to the extent that these patentable subject matter, novelty, and non-obviousness requirements are met. Well, when AI ends up in the mix, what happens if there's generative AI and the machine is what generates the output? What does human conception mean when an AI tool is involved? Is that something that changes versus when a human is not using an AI tool? Is any human still an inventor when AI is used, when generative AI is used to create an invention, some in part or in whole? What happens? So the USPTO and courts had to decide, as this became more and more prevalent over the last few years, well, does use of AI as a tool disqualify inventorship and make something unpatentable at that stage? Does the machine itself have any inventorship rights? And does the level of human involvement really matter? Is that something we're going to get into? And how much human work is enough? Let me pause there and make a really quick statement about inventorship. Under the law, human inventorship is a two-part conclusion. It's fact-based. First off, there's the idea of conception. Did the human inventor conceive in their mind the features of the invention in such a way that they could explain to somebody of ordinary skill how to do it, and it wouldn't take more than ordinary skill to practice it. That's the standard conception. We'll talk a lot more about that. But then you see over there under historical context, number 2, work to reduce it to practice. There's 2 ways you can reduce something to practice that forms inventorship. So conception and reduction to practice are the 2 pieces of invention. Reduction to practice can take one of 2 forms. It's either actual, where you experiment or you prototype and you show that the invention can be made or used by one of ordinary skill for its intended purpose, or you file a patent application with a sufficiently enabling disclosure so that somebody of ordinary skill can make and use the invention. That's what that reduction to practice requirement is. So when you have conception in your mind with reduction to practice, either doing it or filing a patent application on it, you've completed the invention process from a legal perspective. Okay, so that's quite a bit about background about patents, and all that's going to be relevant here in a moment when we kind of get into the USPTO's stance on this. So, few folks mentioned earlier that they had sought and received copyright registration. Well, what is copyright anyway? So copyright is IP that protects original works of authorship fixed in a tangible medium of expression. It's kind of a word salad, but I think of it as the physical embodiment of somebody's creativity, this expressive work that's done, and it gives certain rights to the person who owns copyright. They can distribute copies of the work. They can prepare derivative works based on the original. So I have my nice slideshow here, and it has its content, and I can modify that by adding things to it, changing things in it. Maybe those are derivative works. I'm the one as the copyright owner who has the right to prepare them. They can publicly perform the work. Think about songs. Think about music. Think about plays or different types of creative, expressive performances. The right to publicly perform the work is a very important one. Think about all the things that go into a concert or a tour or a Broadway play or a musical. So the public performance right is very important, as is the public display right. So for art, for paintings, for sculptures, for different types of visible or publicly appreciable art, the right to display the work publicly is a key copyright aspect. Any of these can be licensed out, can be given to someone else in exchange for some value. You will notice that, for example, in the context of the public performance or the distribute and make copies of the work context, if you think about musicians go on tour all the time, and they have public performances of their songs that they've made, but sometimes they're playing the song with different musicians than who recorded the work, or maybe they're playing a different version of the song with different lyrics, or maybe they are performing the work in some way that changes the original work that was on the album that they originally created. There are a lot of different agreements and a lot of different ways that gets sliced up in the process, and that's its own kind of complex industry, the music rights and performance industries. But those rights that you see on the screen here are where a lot of those different rights and the negotiated arrangements for distribution of music, live performances, tours, that kind of thing, merchandise, it all can derive from the copyright that we have. Okay, so this is outlined in the Constitution, and it gives Congress the power to secure rights to authors and their writings. That writing requirement there has been interpreted to be fixation in a tangible medium. You'll notice that last bullet says that when fixation occurs of a sufficiently original expression, that is when protection attaches. It's created from the moment that the fixation is complete, and you don't have to have a copyright registration to receive copyright in your work that you've made. That's a pretty big deal because it means that copyright can be created by somebody who creates with sufficient expression and creation the moment that they do it, and there's no registration process, there's no alarm bell that goes off, nobody's getting told about it, it just happens, and you have those rights from the moment of creation. And that's a very fact-intensive thing. We're going to talk about that a little bit more in a moment when we talk about AI. When AI starts to help you create, there's a fact-intensive question about, well, who did the creation and who did the fixation? So in order to pursue an infringement action, if someone's stolen your work, if someone has taken your work and impermissibly given it to somebody else, made copies, made a derivative work of it, in order to enforce that, you do need registration. That's a requirement for pursuing an action in federal court there. And there are other benefits to registration as well, stronger rights, stronger remedies, and it's something that is strongly advisable. Those of you who've been through the process probably understand that. Okay, so a big distinction, though, between what copyright protects and what it doesn't. Patents, you have an idea that takes shape in the form of an invention, and you're able to conceive of and then reduce to practice the invention. Copyright just protects the expression of the idea, not the idea itself. It's important in the context of AI because AI may be able to take an idea that you have and create output, but the idea is not what copyright protects. It's the expression, it's the output itself, and so we'll talk about that in a minute. So making a Cinderella story or a song about winning a national championship is not something that you can seek copyright protection for. Those things are ideas and are not something that are expressive and fixed into tangible medium of expression. So you might be looking at the term of protection there and wondering, 70 years, the life of the author plus 70 years, why in the world is copyright so long? That's stuff that was made in the 1930s and 40s is still under copyright protection if their author has died less than 70 years ago. Potentially. So there was a different Copyright Act at that time, but that's potentially the case. That came about because of some considerations around what was popular in the United States. You did have things like Mickey Mouse and Walt Disney. There were things that people thought, hey, we want to encourage copyright protection for a long period of time because it's good for public policy. We see there's works made for hire in parentheses in the second bullet. A work made for hire is when somebody hires somebody else or pays somebody else to create a copyrightable expression or work for them. It has to be a writing, has to be in a certain category of works, or it's when an employee creates something that's copyrightable as part of their job for their employer. That's also called a work made for hire, and you can see what the term is there. Pretty long, pretty lengthy, and definitely a powerful form of IP protection. So software that's being written as part of someone's job, work made for hire. As long as the human, and we'll talk about this in a second, as long as the human is the author, right? So when we're talking about using AI to create code, what happens? All right. One example down here that's very relevant for where we're gonna go with this conversation. Burrow-Giles lithographic. A photographer's copyrightable expression is the specific creative choices in lighting, composition, and framing. Back in the early 1900s, late 1800s, courts answered this question. We believe that a camera is a tool that someone can use to create creative expression, and the lighting and the arrangement and the subject and the perspective, all those things are creative choices that the photographer, the author, gets to make. And because of that, we're going to say that's copyrightable expression. The photograph is. But the subject matter itself is not protectable. This came back recently in a monkey selfie, by the way. I don't know if y'all have read about that, but there's a case that addressed what happens, who owns a selfie that was taken by a monkey of some kind. And the conclusion that we'll get to here in about AI in a second is the same conclusion that the court reached there, which is that authorship is reserved for humans. Okay, so different types of works that are copyrightable. You've got literary works, and this includes software and code that's written. This is written expression. Musical works, that's things like songs and the compositions, the written composition of those songs. This is not the recordings, which is a separate category. Plays, scripts, pantomimes, dances, that kind of thing. Those are all parts of dramatic works, and then choreography and pantomime. You also have motion pictures, films, videos, audio-visual works, and recordings, and sound recordings. So that's where, like I mentioned a moment ago, those recordings of artists and their sounds that wind up on CDs or available for streaming, that sort of thing. This is the category that protects that. And then, of course, architectural works, sculptures, that sort of thing are separate, but this is if there's a building or something that's designed and there is a sufficiently creative expression of that architectural work, then it's copyrightable. So again, authorship is the expression of ideas, reflection of the creative choices and control and judgment by the author. Copyright is creative expression, and the ideas and control and creativity that a human has are what really is at the core of this. And it has to be authored by a human who makes expressive choices. This is fairly straightforward when a work is something that is discrete. But when there are multiple parts that come together, and when a human made part of it, and certain elements were created by a human, but certain elements were created with the assistance of maybe an artificial intelligence tool, that's when the question starts to become more fact-intensive and becomes a little bit murkier. So humans are authors because they can't make choices. This is some policy commentary here. And we want incentive for people to create and then have their creations to be protected. Machines are not able to do that yet, and they're not there to create for incentive for commercial or otherwise benefit. So now we're going to get into stuff that's happened like in the last couple of months. I mean, this is stuff that is very recent, and I guess really in 2025 there were some changes that clarified some things. So I want to talk to you a little bit now about what some of those changes were and how they impact when AI is present. Okay, so 2023, the Copyright Office issued some initial guidance on what happens when AI is involved in generation of part of a copyrightable work or a work, what parts are copyrightable. They said, hey, we want to see disclosure of what in your work was generated by AI. If you're going to seek copyright registration, we want to make sure that you're not trying to claim something that you did not, as a human, create through your own individual expression. And that authorship requirement is at the core of that policy. And that was kind of what took shape in 2023. 2024, in February, the Patent Office says, hey, here's how we're going to approach when you have an AI-assisted invention. We're going to use this test for inventorship that was articulated in this case called PANU. And we got a few factors. It's going to be fact-intensive, but essentially it's the same test as when there are multiple human inventors. We're going to say, okay, well, what was your contribution over and above the contribution of your fellow co-inventor, and was it something that was significant enough that we're going to give you the right to be an inventor in this patent application? And unfortunately, that was not as helpful in the context of AI. They give a bunch of examples about inventors and people who are applying for patents who had used AI tools to create part of what they were asserting was their invention. They gave an example about an axle, and a couple of inventors had provided instructions and a prompt to a LLM and said, create an axle that achieves this particular purpose, and there was a design that was generated. Well, in the first example, they said, Patent Office said, hey, that's clearly, not something that was conceived of, or that there's not a significant human contribution over and above what was generated by the LLM, not something that you're a proper inventor of. Well, then another example said, okay, well, what if these folks get that design and say, what would make this more efficient, make it fit better, make it more robust and reliable, easier to service? We can modify the dimensions of it, we can add an angle, we can modify the shape. Those things, over and above what was created by the LLM, is something that could potentially be patentable. That's contributing significantly more to what was created by the LLM. And the Patent Office says, hey, that's on the right track. That's what we want to see. And that should qualify for inventorship. Unfortunately, these examples didn't give full clarity, and it became pretty difficult to fully document what was created by the AI and what was created by and what was contributed by people. There's a fairly burdensome amount of paperwork that you would want to create and maintain if you were going to properly document that process and your contribution versus what was contributed by an LLM. So the Patent Office was not, at least during this period of time, did not have great certainty about AI-assisted inventions, and it was a little burdensome on companies and their advisors as well to be able to advise on, hey, well, what's significantly more under the Panu test here in terms of AI. Then we saw in 2025, there was, with the new administration, an emphasis on AI from an executive order perspective. Lots of AI orders came about, and there was the AI action plan that was intended to accelerate AI innovation in America. One of the first pillars, the three-pillar executive order. And the administration said, we want people to innovate and lead the way in America with AI. So flash forward for a few months, November 28th, 2025, USPTO says, okay, we want to change what we said about how we look at AI-assisted inventions. We're not going to focus on the inventorship test anymore and treat AI like it's kind of a fellow inventor and what did you as a human contribute over and above what the AI did. We're going to say AI is like a tool. It's just like a database or a laboratory microscope or something that you're using to do what you're trying to do. It's simply a tool, and that's how we're going to view it. And we're going to return to the test that we had for time immemorial before, which is that what is the test for invention? Conception plus reduction to practice. When somebody who's a human inventor conceives that definite and permanent idea in their mind of the invention and can explain it to somebody so they can make it without undue experimentation, we're going to say, okay, that's conception. That counts as somebody, as a human inventing. And if you can demonstrate to us that fact-intensive conception occurred, then we're going to say that that's something that occurred and is patentable, or it can properly be conceived as inventorship. And if you're able to articulate what you conceived of versus what the AI model conceived of. Okay, so more executive orders have come out, and these are all super recent, obviously. So some of them less than a couple of months old. There are orders that direct to different agencies, and the National Defense Authorization Act that directs agencies to develop frameworks for how AI is going to be treated. And that's got major implications for those who work with the federal government because it means that there are, for example, prohibited types of AI models that can't be used for different types of work with the government. DeepSeek and models made by High Flyer are prohibited for DoD contracts. And in addition, there is, some now today have to be told or have to be asked, I guess, they have to disclose by parts of, different contracts. They have to disclose what types of AI they're using and when they're using AI. That is already showing up in some agreements, some federal contracts. But there's potentially going to be a new framework. We'll talk about this in a moment. Again, a new framework that will potentially require more information about AI components. And so that could potentially present a risk as well. So my view today is that where things are going is that the patent and copyright system seem to be okay with and seem to be converging on use of AI as simply a tool, but keeping the human expression and the human conception pieces that have been part of the framework forever, keeping those at the center. AI can be used as a tool, but I believe that the patent office is going to want, and the copyright office is going to want, disclosure of how it was used as a tool potentially. When you're filing a patent application, you're only supposed to claim what was actually created by the person and conceived of by the person, and the stuff that was conceived by that was created by the AI tool. You're going to want to make sure that that's not all that's included in your claims, because that's going to be a problem. And so, with that, I wanted to talk a little bit about what it might look like going forward as AI tools are used to create and what new frameworks could emerge. So, again, we talked already a little bit about the Panu factors and this fact-intensive test that was pretty, it's going to be something that was going to be difficult to apply, significant human contributions over what was made by the AI was required, and now we have this conception standard, which is consistent with what's always been the invention standard. I want to point out bullet number 3 on the right, which says human has to form an indefinite and permanent idea of the invention and not just a general goal or plan. So this presentation has not been, doesn't explicitly single out agentic AI. But when I listen to and see use cases of agentic AI and other types of uses of AI, sometimes folks might start out with just a general goal or a plan or a research direction, and the machine might be the one who then comes up with the idea or who then creates maybe that next leap that could be something that is unknown, novel, and if a human came up with it, could be something that could be a patentable invention. That general goal or research direction is not enough to get you to conception. It has to be something that is more definite than that. So we've already mentioned that, of course, when you're using AI, if you're using it as just a tool, maybe for research purposes or to do more faster than you could otherwise do, if you're using it like a tool, like you would laboratory equipment or computer software, that's the kind of thing that will preserve the potential for seeking patent protection for what you've come up with. But there's a documentation benefit, and I'll talk about that more in a moment. Keep what you've come up with versus what the AI tool has generated documented to the extent that you can, because later on, for enforceability and validity purposes in your patent, you may have to demonstrate that. That may be something that comes back and you see it again. Okay, so what does it mean to use AI as a tool for invention? Okay, well, if I use a microscope to discover something, is the microscope the inventor? Of course, the microscope's not the inventor. The microscope is what helps you see something that you otherwise couldn't ordinarily see with your human eyes. The idea of CAD software to generate drawings for a mechanical part, is the person who developed the software or the software itself going to be seen as an inventor? Of course not. There's a human who's using this to generate an idea and express it. We're not talking about copyright, but that's the context is I've come up with something new that gets me a superior mechanical part. I've just used CAD as a tool. Well, what if we have a chemical compound that we think might work, and we have a database with a significant amount of chemical compounds in it? We consult that, and we use that to determine that our new compound is going to work, and the answer is no. It's still the human researcher who is the inventor there. That gets us to number 4. Well, if I use an AI as a tool, okay, as just a tool to help me develop something, is the AI an inventor? And patent office said no. What does it mean to use an AI as a tool? I think there are a lot of different ways you can do that, but the key will be that the features, the limitations, the things that make your invention new and non-obvious are going to be the things you don't want to have the LLM generate. You want to be able to demonstrate that I knew that these key features here were going to exist. I use the LLM as a tool to help flesh out additional color around the edges or things that I otherwise couldn't have done with my mind and as part of my human capability set. And so that's something you can document and try to make sure that there's an accurate reflection of what was conceived by you versus by the machine. So let's get down to the plain English here. Does the inventor understand the invention? If you just entered that prompt with a general goal of designing a better axle or designing a superior teleprompter system or something, and the AI was the one who came up with the features, well, you could have a display that's positioned here that communicates with a mobile device or something like that. All those little limitations and features came up with, the AI came up with that, not you. Not going to cut it, and so you want to be able to explain and understand how it's working and why it works. Is it just a general goal or a plan? Is it something that somebody else could build based on the description that the inventor has? So we've already been through some of the USPTO's inventorship guidance examples, so we won't go through those again. So again, using AI as a tool is where we want to keep it, and we want to make sure. Number two there is really where I think it's going to be challenging. So as far as I know, and I would like to know if there's someone who maybe has experience with this, but having an audit trail of what was created with different types of AI tools, I don't know the extent to which each of the agentic solutions that's out there now is capable of producing that. But those audit trails and logs of what was created and contributed by a person versus what was contributed by the machine or created by the AI model, that's a great way to document what was done and what was created and who came up with it, how things were modified, how outputs were combined, how they were rejected, how they were modified, how there was correction of the model in the machine in order to achieve what you wanted. Those are things that can prove conception. If you have good documentation, when the time comes for the patent to be enforced, whether that's or asserted, whether that's through a direct licensing arrangement, or if perhaps your patent is challenged by somebody who believes that they could be accused of infringement, or if someone is blatantly infringing and negotiations and resolutions are unsuccessful and you need to to assert it in court, it's important to have a properly documented and robust explanation for what conception occurred by humans versus what was contributed by AI tools. Contemporaneous records are going to be very helpful in establishing that. Number 4 here, the last one, is something that you'll see a couple different times. Talk to your lawyer. And do it early and do it often and make sure they know what you're working on, and work with somebody who's familiar with the AI and IP topics that we're talking about today. Someone who understands generally what your IP strategy is and how you want to achieve protection. If you really don't care about licensing certain of your technology or achieving good copyright protection for the code you're generating, if you're using a machine to generate most of your code, vibe coding or whatever, and you really don't have protection of that code as a strategy for your commercialization or value building at your company, that may change some of the practices and recommendations. But it's always good to keep an attorney involved who understands the IP issues here and how AI affects those and where things stand right now. Okay. There we go. So let's talk a little bit about the Copyright Office approach, because I think, I don't know how much of this you can see. Oh, super, okay. Well, as long as y'all are able to read what's on this slide here, that's great. So the conclusion of the Copyright Office is, look, the Copyright Office believes that the Copyright Act of 1976 and copyright law we have adequately accounts for AI. It adequately accounts for the distinction between human expression and machine expression. So we don't think that Congress needs to act, and we don't think that there's a need for new legislation in this regard. We're going to focus on human copyright, human authorship rather, and that's all part of what we have established for a long time. So we're comfortable with that. AI tools can be used. AI can be used as a tool for expression. That can be things like, and we'll talk about this in a second, but examples where the Copyright Office identified a drawing of a human face that had some different features. It was like half of a face, and someone used AI to enhance and add new kind of texture and color and dimension and depth and shading to that drawing. And the Copyright Office said, the human perceptible expression here is protectable with the AI enhancements, but the AI's expression itself, what it added is not going to be something that's human expression, not protectable. So the Copyright Office is looking for those facts because those things can separate what is a protectable part of your registration and what's not. Randy Travis was mentioned in the Copyright Office's guidance as well. I am not a particularly strong follower of Randy Travis. If you are, that is great. You may, whether you are or not, you may know that Randy Travis has had some declining health issues, and turns out he had a stroke. So there was a song that he wrote, maybe in 1994 or something like that, but I don't know that he ever recorded his voice to it. Or if he did, there's an opportunity to re-record the song with new musicians, and we wanted Randy's voice to be in that recording. So what was done was there was a new recording that was made of the instrumentals and the composition, and a human sang the lyrics. That wasn't Randy Travis. But there was enough examples and data of Randy Travis's voice for a model to learn what Randy's voice sounded like, and for that donor vocalist voice to be changed and modified based on Randy Travis's voice and what the model was able to learn and to apply there. So you have these overlays. I just talked a little bit about the overlay of a AI, graphics over a human-generated art. This was Randy Travis's lyrics and song and melody, et cetera, that was recorded by real people as well, and then an AI vocal track was laid over the human instrumentalist, vocalist recording. So the Copyright Office registered that and said, yes, this is sufficient human expression for us to register, but the AI was used as a tool here to enhance the work, to do certain things that the humans were able to control about it. There was sufficient human control that was exercised. It wasn't simply a prompt, hey, make this sound like Randy Travis. It was something that was sufficiently curated, edited, and controlled by people. Expression was there, and so the Copyright Office was able to register it, and they specifically mentioned that in their report on copyright protection. Okay, so just a quick comparison again. Who conceived of the invention? Was it human or machine? Is what the Patent Office is going to focus on in the patent system. Copyright system is going to focus on who's the one who expressed this tangible medium. Not the idea, but the thing that's actually the work. So we want to make sure that people use AI just as a tool and use it for human, and human conception remains at the heart of somebody's invention. When you're applying for a patent, your patent application needs to articulate as patentable claims human conception, not AI. Something your patent attorney or patent agent ought to be able to identify and discuss with you. So copyright, AI as a tool is fine. You just want to make sure that human creation remains. All right, so what about prompts? AI prompts that people generate, sometimes very lengthy, sometimes very sophisticated. The syntax is something that is, many times an art that people learn and is something that is difficult to master. What about for prompting? Prompts are not protected on their own because it's just something that is not, it does not provide the sufficient human control. So once you provide the prompt to the AI system, whatever happens inside the AI system, there's the term black box that continues to be used around what goes on inside of an AI tool. And so when you provide this general prompt or this specific prompt to the AI tool and there's an output that's generated, the Copyright Office and other courts as well have said, hey, we don't see there being sufficient control over the output to make this an expressive work of authorship by a human. Whatever's generated as output is not going to be protectable by copyright. So that's a little bit, that's the same principle when you think about it as using a camera. When I use a camera, I know that when I click the shutter and I have the exposure, I've got the aperture, I've got all the different settings on the camera that I control. I have the lighting, I have the subject, I have the distance, I have all the features of the shot that I am controlling as a person, and I know that when I click the shutter, I know what's going to happen with the camera. At least I hope I do. When you put the prompt into the LLM or the generative AI system, there's less control. You know what you expect, and maybe what comes out is close to what you expect, but there's certain things about the output that aren't sufficiently within your control to make it something that is copyrightable by humans. So using it as a tool to create on its own is not the same as using it as a tool to enhance or to edit or to modify a human existing work that is already there. So you cannot copyright pure AI generated outputs. But if you take an AI output and you create a selection, an arrangement, a modification of multiple outputs, and you have a work that is a combination of that has your human creative selections and expressions in that, then that could be copyrightable and probably is. So again, not enough for prompts alone. There's sometimes a prompt output with human creative selection that can be copyrightable. The standard for creativity under U.S. copyright law is a modicum of creativity, like very low, very small threshold for creativity. You just have to have a little bit. So a prompt with human creative selection, if there's an arrangement that is sufficiently expressive, yeah, you can get that. Like the phone book is, or just flat data that is not, that's not particularly arranged in any creative or selective way, probably not copyrightable. But the prompt output, if you're going to combine all those different outputs with substantial human modifications, can be copyrightable. And so that's an example of how you can use AI as a tool to create something that's potentially copyrightable. Okay, so I mentioned a moment ago the example about the human sketch of a human face that somebody generated, and then there were some new features that were enhanced. That was found copyrightable. And then, of course, if you just say, hey, please go ahead and create me a beautiful mountain landscape, and the AI generates a landscape, that's not going to get us there because there's not enough control on the part of the human to make it the human's expression. Okay, we've already been through example number 3, where we're talking about this idea of having an enhancement to a human-created drawing. The human-created elements are where the limitation is going to be. And then, of course, the selection and arrangement of AI-generated images, modifications there, and those things are going to be things that can give you copyright protection when there's an expressive choice that a person is making. So, okay. I want to pause and kind of shift over to what the federal government is right now, and potentially will go with its AI policy just based on things that have happened recently. Okay, so recent, executive order on AI national policy, where there's certain agencies that have been directed to perform evaluations within 90 days and come up with certain frameworks and make certain determinations. So the National Defense Authorization Act that I mentioned a moment ago, there's this restriction on AI that comes from a covered AI system or a covered entity, and DeepSeek, High Flyer, or the countries that are listed there are where the covered AI definition is going to apply. So if there are systems that are being used that are provided by a vendor or that rely on open source AI tools or models, it's important to understand whether they have a connection to one of the entities here that's a covered entity, and therefore itself becomes a covered AI. There are waivers available potentially, but that's not something that anyone should rely on, of course. You ought to plan on just avoiding that where you can. So as more and more folks build AI into their systems and build it into the solutions that they're offering in proposals and for contracts, you want to make sure that that anything that could be potentially related to or incorporating an AI that's covered AI or from a covered entity, you want to limit that and understand where it is and remove it when possible. So what's going to happen next? Under the NDAA, we had Section 1512 that says that there's got to be a cybersecurity and governance policy within 180 days that DoD needs to develop, and we'll see whether that timeline remains or whether that's extended. Also have to develop cybersecurity and physical security frameworks for AI and ML systems, which, again, that's something that has to take place. Congress suggested in a joint explanatory statement that accompanied the NDAA that potentially we might want to have software bills of materials that could be applied to AI systems. This is something that is not a requirement yet, but potentially could be. And if it is, then It's possible that information about things like the AI model that you're using, the training weights and the data sets that were used to train the model, and additional information that could be right now protectable as a secret or a trade secret and confidential information of someone who's a government contractor, that stuff could be on the requirements list for a software bill of materials. That remains to be seen. The CMMC, cybersecurity framework, could end up being incorporated, with AI specifics out of this directive under the NDAA. So we'll have to keep our eye on that and see what's going to happen. And you might end up having to, again, disclose as part of performance of a contract or submitting, a proposal for a contract. You might have to disclose information about the AI systems you're using, not just say, I promise I'm not using AI from any covered entity or any covered AI tools. So we're going to see what happens. There's some important dates coming up that were mentioned in the NDAA, and we're going to see whether these dates hold and whether there's additional information that comes out in the meantime, because executive orders and guidance seems to be appearing, very frequently, and so, how additional things that happen between now and April 1st will impact this timeline will be something we'll want to watch. But as always, this is something that you can monitor with your lawyer and have someone who understands what requirements are going to apply to federal contracts and the AI you're using at your business. Okay, so again, here's some tips for inventors. Let's make sure that there's a documented, version-controlled invention disclosure form that you have. Understand that this is not the pre-AIA first to invent process anymore. We're not having to prove up, well, I invented this in 1988 and you invented this in 1992, and so I win. This is the American Invents Act era. Since 2013, like we've got first inventor to file is the one who gets the patent, and so but it's still important to keep a dated and version controlled document of an audit trail or whatever of what your team was working on when you came up with certain features. It may not seem like the key breakthrough that you're really going for and want to pursue, but just understand that the more detailed information you have about who came up with what and when and what wasn't generated by AI, the better chance you're going to have for a robust argument if it's ever an issue, if you get a patent on something and there's a dispute around it and there's a challenge to it. So keep things in mind, like what problem you're solving, when you started working on it, before you tried using AI, what did you try doing? Did it work? Did it not? And what features are patentable about this invention as far as you know, and that'll give you some pretty good documentation there. You also want to mitigate risk, and one of the risks you want to mitigate is typos in the title of the slide. That's or the area there. So you do want to pay attention to that. So I will say poor documentation can make you lose out. It's something that you just, again, I can't express how important having good documentation is going to be, because conception is going to be a fact-intensive determination. If it's ever challenged, hey, we think you guys use AI to create this, you want to have good documentation and invention records. Also, good AI use hygiene. What the heck does that mean? Anybody have like AI acceptable use policies that they have to abide by? Oh yeah. How many people use AI for their work outside? They're not supposed to be using it for their work, but they use it on personal time. That happens all the time. Don't raise your hands. That happens all the time. It happens all the time. And unfortunately, that's even with acceptable use policies, that's something that happens. Avoid using AI for your work stuff outside of the approved ways that you can use AI for your work stuff. Don't go home and keep working on it on your personal computer with your personal AI login subscription and account, and then come back in and say, I got it, I got the breakthrough. Because that's when we run into these issues about inventorship. Who conceived of something? Well, now my trail and my records of what happened for the team in the development process, there's a gap. Or even worse, somebody tries to hide their use of this, and there's something factual that later some attorney's going to ask you, Mr. Smith or Miss Jones, please tell me more about this particular feature and how you developed it. Well, and isn't it true that you use so-and-so? Those are things that people think will never become an issue, but potentially can. So follow best practices, use good AI use hygiene, and if you don't know what that means, there's some good resources available that we can put forward to you from the AI task force, actually, the AI Huntsville AI task force the mayor mentioned a moment ago. All right, again, litigation advantages, commercial advantages, confidence when it comes to preparing a patent application, understanding that your invention has these key concepts that didn't have any contribution from a machine. A human's in the loop. The human's the one who came up with it. Your patent attorney is going to be happy. Patent counsel is going to be happy. It's going to give you an advantage. You can have higher confidence and likely fewer challenges when it comes to articulating, what you did and what you didn't do, and it can enhance, speed up your filings. So it can also reduce prosecution costs. So that's a benefit there. But always keep your IP attorney involved. I'm going to keep going back to that. Make sure you talk to your lawyer. Hiding things from your attorney, telling them half-truths or leaving things out can really impact outcomes, and it's never a good idea. Waiting too long to call them, also not a good idea. I know that attorneys can be the last people that you want to talk to at times, but it's very important, and keeping them in the loop, whether it's your in-house counsel or somebody outside, want to make sure that they're aware of what you're doing and how you're using AI. So assessing proper use in the inventive process, making sure that there are proper responses to patent office actions, that sort of thing, all good stuff. So really quickly, we're close on time here. Defense contractors, there's going to be a lot of stuff coming out, I believe, in 2026. We're going to keep our ear to the ground, but please make sure that you are aware of potential AI issues, whether it's covered entities, covered countries, covered AI, that any of the resources and tools you have, if they incorporate these problematic tools and problematic AI features and resources, make sure that you know that. Make sure you discuss it with your lawyer, and to the extent that there's going to be modifications necessary, understand what you need to do and how to make sure that none of those have impacts on your contract's performance. That's kind of the suggestion there. If you are relying on things like model weights and training data and model selection, that sort of thing, interplays and loops and other things that could be potentially trade secrets, right? So trade secret, something that is not generally known, that you take reasonable efforts to keep confidential, that if it was known in the marketplace, it would have significant commercial value. That's protectable as a trade secret. The stuff that I just mentioned is stuff that a lot of people might want to treat as a trade secret. Are you going to have to disclose that potentially? That's something to understand. Understanding whether maybe you've got the opportunity to have commercial versus government solutions when it comes to AI, and how those might be different. The commercial solutions, you may not have to disclose those things, and that strategy is something you can discuss with your IP lawyer. Okay. So again, reviewing components of the AI systems, making sure that they are compliant, and then assessing your trade secret strategy. Do it now, don't wait, because even though the guidance has not and framework has not been finalized, and you don't know for sure yet all the things you're going to have to do, you do know that it's a good practice to go ahead and document what you're using, where it came from, and how you use it. And you potentially may want to identify any alternatives. If you do identify any problematic covered entity or covered AI tools that are in your stack, you may want to go ahead and identify additional resources that can replace them to the extent feasible. And I know I'm talking about this as an attorney, and all the technical folks in the audience are going, it's not that simple. I understand. Okay. Lastly, just keep your ear to the ground, because the guidance is going to be coming about. The frameworks that have been directed under the NDAA from December, and there's going to be quite a bit of news, I believe, this year around AI and how it shows up in Department of Defense contracts. So get up to speed, talk to your attorney, monitor guidance, document your work. Those are the things that I would like to leave you with today. And again, this was not specific to the agentic AI context. When I'm talking about AI in this presentation, I want it to be broad enough, because not everyone is using agentic AI yet. But when you're using agentic AI to do things and create things and do tasks for you, keep in mind that the expression and the conception that makes human contributions protectable under copyright and patent law, that can go away when you're using agentic AI. That can go away when you're not the one who's doing it. So keep that in mind. And it wouldn't be an attorney presentation without a little bit of a disclaimer. So disclosure. I was able to use Claude to generate certain aspects of this, but the citation gathering, formatting, all that stuff, I did. And I'm able to research and make sure that these things are accurate and current. So also, not your lawyer, and I would say that there's no, all the disclosure requirements under the Alabama State Bar's legal and ethics section, professional responsibility section, no representations made. Okay, with all that, I've talked a ton, and I'm not sure how much time we actually have left, but maybe we have a little bit of time for a question or two.
Yeah, we have a couple of minutes for questions, but again, because of the legal advice, if you have a specific question about a project, talk to him offline. So we're talking about the broader issues. Again, we've got mics going around, and I think we've got some questions over there. And Ryan will be here all week, so.
All week.
All week.
Okay, got a lot of questions.
Hello.
One for right now. Some of the prompts that we use for agentic AI specifically can get into the thousands of lines. Can I copyright a prompt itself?
Yeah, so as I understand it, so the prompt itself that a human
Yes.
creates, thousands of lines. Yes.
All right.
Yes, that's copyrightable. Now here's a caveat. Copyright registration requires disclosure. You got to tell the public about it. You got to put a deposit copy on file with your registration application at the Copyright Office. So talk to your attorney about how to protect anything you think is a trade secret in your thousands of line prompt that your humans created. Okay.
Hi there. I'm over here.
Hello.
I had the fortunate experience of talking to an IP attorney from the USPTO a few years ago, and I asked the very question about the prompting. And their guidance was you have to demonstrate, like you said, the human creativity in the process, but her answer was put it in, document the prompt, and you can then, have that protection. What about in the agentic world, having exploded in the past couple of years, what about those workflows? Can you document some of that? That even harkens back to early 2000s when you're documenting business models. Can you talk a little bit about that?
Absolutely. That's a fantastic question. And so let's go back to what copyright protects in the U.S. Original expression, fixed and intangible medium. Your workflow, did a human write that workflow? Is it something that's fixed and can be virtual, can be on a GUI or whatever, can be in a program, but is that workflow something that a human created? And to the extent it's sufficiently expressive and creative, which I think it probably is, yeah, it probably qualifies for copyright registration or protection. The question will be, do you want to make the trade of disclosing it if you need to get a copyright registration for it? So yes, so copyright protection in the U.S., copyright. At the moment of fixation, moment of creation, author gets rights. That's it. To get registration, you have to do the disclosure and application and all that. Do you want to do that and disclose your workflow, or do you want to keep it a secret? Those are the questions that you might have to answer. So I do think as long as a human wrote the workflow, your agentic AI might execute that. But just like instructions in software are subject to copyright protection, and they instruct a computer and a processor to carry out steps and instructions, if you're doing a workflow that your agentic AI is following and then you created it as a person, as a human, yeah, I think that's probably going to qualify.
You mentioned earlier, if I prompt the AI, create a better widget, and then just copy and paste, that can't be copyrighted. But what if you continue using the AI to research the solution to where you learn it well enough to explain it, and then you still use that original solution once you find out it's workable?
So it sounds like maybe what you're describing would be using AI for research.
Using it to create the idea and then to research the idea.
To create the idea and then to research the idea. So the test, again, is whether what you've claimed in your patent application, the features of the invention as you've articulated it, is that something that you conceived of and had the ability to describe to somebody of ordinary skill so that they could do it? If the AI was the one who created steps A through C, and you maybe thought, oh, I can do step D as well. Hey, if I do step D, can I do E, F, G, and H? And the AI says, yeah, you can. Then as long as you have A through H, maybe, but I think you would want to, like, D, maybe what you're limited to is in terms of like D will always have to be there. I don't know that you could really get away from that, because the only thing you conceived was that feature. And that's a very interesting example, because that gets you into like, well, your conception was just this one piece, and there's a bigger piece, there's a bigger chunk in the claim of what you're doing. So we'd have to probably get more specific about what it is and what your conception, or what your contribution was, before we could say, yeah, okay, that's probably patentable. But if you're doing that, I think it is important to delineate, well, A through C came from the machine, D was me, and then the rest was the machine too. Okay.
Hi. What if you programmed the LLM and fine-tuned it, and in the entire process, a human was a part of it?
So the question is, if you're the one who's exercising this supervision and configuration, the training, et cetera, of the machine, are you talking about like patent rights or copyrights,
I would say
or
patent
in general?
rights, because before, if you put in that black box or whatever, but you programmed the black box, you fine-tuned it to your data and all of that, then do you have a case?
And then, so the person who's done the things you just said uses that to get like some solution over here.
Mm-hmm.
Okay. So I would say it depends, but I'm leaning toward no, and here's why. Because conception is, you have to have that definite and permanent idea is the legal standard, but more than just a general goal or a plan. Like that's the terminology that the case law and the patent offices use. It's like more than just a general goal or plan. So when you're creating the training data set and the weights and the model and all the configuration that you're putting together, if you already have the steps and the output, right, in mind, maybe. But if you don't have that in mind yet, and you're putting all these things together in this AI system with the goal of generating that AI output, the output that the AI generates, the AI generated the output, there's a general plan, a goal, a design back here to achieve that, but the AI was still the one who did it, rather than the person coming up in their mind with what it would be and all the steps in the output. So if it's that stark a scenario, probably not. Now, if I've got 87 steps out of 100 in my mind over here, that might be a different scenario. But I think it would depend on the facts. Again, it's a super fact-intensive analysis. And under the facts, there's probably 2 or 3 different scenarios we could come up with or more where the answer is leaning yes, the answer is leaning no.
Okay.
Thanks for the informative presentation. Could you skip back to the DoD contractor slide?
Sure.
I failed to get a picture of it. So I realized that at the moment of creation, right, you had a copyright in it, so I won't infringe on your copyright. I just want to get a picture for my notes.
Which ones were you thinking of? This one?
You had a summary with like the 4-way, I think.
Oh. Is it? Uh-oh, I'm going the wrong way, sorry. Is it this one? Or this one? Okay. Any particular question about it, or just? Okay.
Well, so you mentioned model weights, for example. Are model weights considered to be AI controlled by a foreign adversary, or does that have to be executing software?
I think and so the question was, are model weights, what aspects of an AI system might be encompassed within what could potentially be required for disclosure? I think the answer is probably, like commentators believe that that's probably something that would be information that could be disclosed or required to be disclosed. Pardon me. Yeah, and like the prohibition is on the covered entities and the covered AI. The disclosure requirement is separate. That's what, and that's not fully fleshed out. So, it very well could be you have to give information about things like that. But we're going to have to stay tuned.
All right. We've got one more question over here, and then our speakers, again, will be around if you guys want to talk further.
So my last question is about digital twins. not just people, but actual things as well. Can you address that?
Okay, so digital twin, when I think of it, is a virtual representation of a physical system, the state of a physical system. Is that fair? Okay. From the aspect of patentability or copyright protection, in which context do you want to know more about maybe IP rights associated with? Okay. Yeah. So, the idea of that is I mean, there are numerous patent applications and issued patents that cover different aspects of digital twin software implementations and systems. So, clearly the patent office thinks that there are aspects of that are patentable. So, yeah, and then from a copyright perspective, code that's human written that implements a digital twin system and has, remote sensors of, physical systems that are able to be replicated in software. Yeah, that's all stuff that, software that's authored by humans. I think copyright has the same overlay there. Is that helpful?